Welcome to Ipob Rapture Media. In a legal showdown that could single-handedly dismantle the federal government's entire case, the leader of the indigenous people of Biafra, Mazi Nnamdi Kanu, representing himself, delivered a masterclass in constitutional law that has left the prosecution reeling. The scene was the Federal High Court in Abuja, but the stakes are a question that strikes at the very heart of Nigeria's justice system. Can you be tried for a crime that doesn't exist? What unfolded was not a mere procedural hearing. It was a systematic dismantling of the government's charges brick by brick, citing repealed laws, international treaties and binding Supreme Court precedents. This isn't just about one man. It's about the rule of law itself. Here is the full, explosive breakdown. The dramatic court hearing centered on a series of fundamental legal motions filed by Mazi Nnamdi Kanu, who is acting as his own counsel. His argument was simple yet devastating. The prosecution's case is built on a foundation of sand, relying on laws that have been formally repealed and no longer exist in the Nigerian legal statute books. Kanu invoked a powerful arsenal of legal instruments, Sections 36(1) and 36(12) of the 1999 Constitution, as amended, the Evidence Act. 2011, the Terrorism, Prevention and Prohibition Act 2022, TPPA 2022. His central contention is that the prosecution's charge sheet is fatally flawed, relying on the Customs and Excise Management Act, CEMA, which was explicitly repealed and replaced by the Nigerian Customs Service Act 2023. Similarly, he argued they rely on the Terrorism Prevention Amendment Act 2013, which was wholly repealed and replaced by the newer comprehensive TPPA 2022, the constitutional bomb, Section 36(12), and the non-existent offence. This is where Kanu's argument strikes its most powerful blow. He directly challenged the court with a constitutional question rooted in Section 36(12) of the 1999 Constitution, which is a cornerstone of justice in any democracy. This section unequivocally states, "A person shall not be convicted of a criminal offence unless that offence is defined, and the penalty therefore is prescribed in a written law." Kanu's legal logic is inescapable. The prosecution is using charges based on repealed laws. A repealed law is, for all intents and purposes, a non-existent law. Therefore, the offences they are alleging are not defined in any existing written law. Consequently, to proceed with a trial on these charges would be a direct and grievous violation of the supreme law of the land, the Nigerian Constitution. He therefore urged the court, as the guardian of the Constitution, to strike out the charges in their entirety, insisting they do not constitute any offence known to law. Binding precedents and judicial notice, the Supreme Court's command. Kanu did not stop at a theoretical constitutional argument. He fortified his position with binding judicial precedents, demonstrating a sophisticated understanding of legal hierarchy. He cited the Supreme Court's decision in FRN versus Nnamdi Kanu, SC CR 136/2022, arguing that lower courts are bound to take judicial notice of repealed laws as stipulated under Section 122 of the Evidence Act 2011. The argument here is procedural yet fatal. If a court fails to acknowledge that a law has been repealed, especially when it has been formally brought to its attention, it is operating on a false premise. Kanu asserted that such a failure renders all proceedings void, meaning any judgment stemming from such an error would be legally stillborn and subject to being overturned on appeal. He further bolstered this point with other landmark decisions. Ayoko versus Fagbemi, 1961. 1. All NLR 400. A classic case establishing that a conviction cannot stand if it is not based on a valid existing law. FRN versus Ifegwu 2023-15 NWLR Traitores 1842 Page Action 13, a more recent affirmation that convictions based on non-existent or improperly applied laws are fundamentally null and void. This creates a powerful narrative. The government is not just wrong on the facts, but it is asking the court to make a decision that the Supreme Court has already declared illegal. The international law violation. The Kenya extraterritoriality problem. In a stunning revelation that expands this case beyond Nigeria's borders, Kanu challenged the very jurisdiction of the court over allegations related to his alleged activities in Kenya. He invoked Section 76(1) DT of the TPPA 2022, which contains a critical safeguard for extraterritorial jurisdiction. This section requires that for an offense allegedly committed outside Nigeria to be tried within Nigeria, the conduct must also constitute an offense under the laws of the country where it was committed, and this must be validated by a certificate from the Attorney General of that foreign nation. Kanu's legal team argues that the prosecution has failed to provide any such certificate or validation from Kenyan courts or its Attorney General. This omission, he contends, is not a minor technicality. It nullifies the cost of extraterritorial jurisdiction and represents a blatant breach of Article 7 of the African Charter on Human and People's Rights, Ratification and Enforcement Act, which guarantees every individual the right to have their cause heard, including by a legally competent court. The ultimate constitutional argument, the Supremacy Clause. Weaving all these threads together, Kanu returned to the foundational principle of the Nigerian state, constitutional supremacy. He cited sections 1(1) and 1(3) of the 1999 Constitution, which state, "This Constitution is supreme, and its provisions shall have binding force on all authorities and persons throughout the Federal Republic of Nigeria. If any other law is inconsistent with the provisions of this Constitution shall prevail, and that other law shall, to the extent of the inconsistency, be void." His argument is a syllogism. The Constitution, S. 3612, prohibits trials for undefined offences. The prosecution is trying him using repealed and thus undefined laws. Therefore, the prosecution's actions are inconsistent with the Constitution. Under Section 1(3), those actions are void. The final demand and the countdown to November 4th. Concluding his landmark submission, Nnamdi Kanu made clear time-bound demands of the court. He asked the court to direct the prosecution to respond to his motions strictly on points of law within 3 days. He demanded a ruling on or before November 4, 2025. He clarified that his application raises purely constitutional and legal questions derived from existing valid laws, and therefore does not require supporting affidavits, as it is a matter of law, not fact. The courtroom was left in a state of legal suspense. What Nnamdi Kanu has achieved is to frame the upcoming November 4th hearing not as a routine date in his long-running trial, but as a referendum on the Nigerian judiciary's willingness to uphold its own constitution against executive overreach. If the court agrees with his arguments, the entire case against him could evaporate. If it ignores them, it risks creating a constitutional crisis and affirming the fears of many that the rule of law is negotiable. This is no longer just the case of FRN versus Nnamdi Kanu. It is the case of the Constitution versus political persecution. Thanks for listening. Please don't forget to support the ESN at www.ipob.org.